All right, let's talk about your rights at work. We're going to break down Malaysian employment law, cut through all the jargon, and make sure you walk away knowing exactly where you stand.
So let's just dive right in with the biggest question on everyone's mind. In Malaysia, can your boss just fire you for any reason at all, at any time, with no warning? The answer to that is a hard no. And this is a really big deal because it's totally different from the at-will employment you might hear about in places like the US. Here, the whole system is built on a principle called just cause or excuse. What that means is your employer has to have a good, fair reason to let you go. And get this, it's on them to prove it was fair, not on you to prove it was unfair.
So here's the game plan for this explainer. We'll start with the legal basics, then look at your day-to-day rights on the job. After that, we'll get into that shield against unfair dismissal, figure out what a fair firing process actually looks like, and finally, wrap up with what you can actually do if you think you've been treated unfairly.
Okay, first up, your legal foundation. You see, that employment contract you signed, it's really just the beginning. It doesn't just exist on its own. It's actually built on top of a much bigger legal framework.
And that framework basically stands on two huge pillars. You've got the Employment Act of 1955, which sets all the minimums, your pay, your leave, your working hours. Then there's the Industrial Relations Act of 1967. This one is all about the relationship itself. And crucially, it gives you the legal power to fight back against an unfair dismissal. And if there's one golden rule to remember, it's this. Your contract can never, ever give you less than what the law says you're entitled to. If a clause in your contract tries to undercut the legal minimum, well, that clause is basically worthless. The law always, always wins. So, what are these minimums the law guarantees? That brings us right to Section 2, rights on the job. Think of these as the entitlements that are absolutely non-negotiable from the moment you start.
Let's start with your time. A huge change back in 2022 brought the maximum standard work week down to 45 hours. And listen, this isn't just a suggestion. It's a hard legal limit to protect your work-life balance. If you're eligible and work more than that, that's overtime and you have to be paid for it. Simple as that.
Next, let's talk money. The national minimum wage is set at RM 1,500 a month. This is the absolute floor. It doesn't matter what your job is or where you are in the country. This is the baseline designed to make sure everyone has a minimum standard of living. The law also makes sure you get time to rest and be with your family. It lays out clear minimums for leave. Your annual and sick leave actually increase the longer you're with a company. And so important, it mandates 98 straight days for maternity leave and 7 straight days for paternity leave. Now here's a really powerful new right that you need to know about. You can now formally ask for a flexible work arrangement. This could be about changing your hours, your work days, or even working from home. And here's the best part. If your employer says no, they can't just brush you off. They are legally required to give you a solid reason in writing. All right, let's get back to that core protection we talked about at the start, the unfair dismissal shield. It's time to really dig into what that phrase, just cause or excuse, actually means in practice. This quote right here is everything. It completely flips the usual script. The burden of proof, it's on the employer. They're the ones who have to convince a court that firing you was justified. You don't have to prove it was unfair. That is such a critical difference. But what if you're the one who quit? What if you just couldn't take it anymore? Well, that's where this idea of constructive dismissal comes into play. If your employer made your life miserable, say they demoted you for no reason, or created a toxic work environment, and you felt like you had no choice but to resign, the law might still see that as a dismissal, and it's something you can challenge. Okay, so if an employer needs a good reason to fire someone, what actually counts as a valid reason? Let's get into what a fair dismissal process looks like, because even if they have a reason, they still have to follow a fair procedure. Usually, a fair dismissal boils down to one of three things. First, serious misconduct. We're talking theft, fraud, things like that. Second, consistently poor performance, but only after you've been given a real chance to improve. And third, a genuine redundancy, which means the job itself just isn't needed anymore. When it comes to poor performance, the process is absolutely key. An employer can't just wake up one day and say, you're not cutting it. They have to prove they followed a fair path. First, they have to set clear standards so you know what you're aiming for. Then they have to give you formal warnings and offer real support, like training or a performance plan to help you improve. Firing you is the absolute last resort, only after everything else has been tried and failed. And what about in a redundancy or layoff situation? Again, fairness is everything. The most widely accepted method is the last in, first out principle, or LIFO. It's an objective way of doing things where the employees who've been there the shortest amount of time are the first to be considered. It helps prevent managers from just picking and choosing based on who they like. Okay, this brings us to our final and maybe most important section, what to do next. If you truly believe you've been unfairly dismissed, here is your roadmap for what to do. The path for challenging a dismissal is very clearly laid out. First, you have to act fast. You have a strict 60-day window from your dismissal date to file a representation at the Industrial Relations Department. After that, a conciliation meeting is set up to try and work out a settlement. If that doesn't work, then your case can be sent up to the industrial court for a full hearing. So the biggest thing to take away from all this is that even though facing a dismissal is incredibly stressful, you're not on your own. There is a clear, structured, and accessible system in place that is designed to make sure your side of the story gets heard. We've covered the law, we've covered your rights, but it leaves us with one final thought. Knowing your rights is absolutely the first step, but how do we get beyond that? How can we help build workplaces where these laws aren't just the safety net we fall back on when things go wrong, but are the actual foundation for a culture of respect and fairness every single day?